And the judge met with this witness, with the prosecutor, and you sat next to me and Mr. Adams, you would say to us, what kind of case is this? Now he's being surrounded with all this law enforcement. My point is,
Your Honor, we're going to object that this...
I'm not going to be interrupted.
And we are back, Hello, everybody. Thank you for watching this series, the Mistrial Madness series. Go ahead and hit that like button. Come on, y'all. Do your boy a favor. Hit the like button. It only takes a second. Y'all, we are going to get into some more mistrial petitions today. They are coming fast and furious. I'm calling these the Woody tapes because these are all the mistrials that I could find in court while Woody was on the stand during his first go around, during his Glanville era. Okay, this is the Woody Glanville era. There's more than you would imagine here, y'all. Trust me. There's some things that you forgot about in here. So this is not too long of a video, about an hour 15. So it's not quite a sit back and relax, but go ahead and sit back and relax anyway. We want to thank y'all for watching. Again, don't forget to like, comment, and subscribe, and let's get into it.
All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face Deputy Hand and be sworn as a witness.
Raise your hand. You swear affirm the testimony you're about to give a quarter of the truth, the whole truth, nothing but the truth, help?
Yes.
Maybe see if you state your first and last name with the spelling of both, please.
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland. Mr. Copeland, do me a favor. Pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
KennethCopeland.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From.
All right, sir.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody. All right. State, do you have any other witnesses you plan on calling this afternoon?
No, Your Honor.
Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
And then, Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question. So at this point in time, there's really, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt, because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. The last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and They've heard Mr. Copeland's name however many times a court reporter said.
Casey, that's what we've heard.
No,
So.
the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's a killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has...
I don't want to interrupt you. Your Honor, I'm just telling the court I am not accepting the proffer.
Your Honor, if I may...
Okay, but counsel gets the proffer, Mr. Steele. I can accept that. So, could you sit down at that time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relay to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down and I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses, this particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks. And after Mr. Copeland has communicated to this court, he will testify. So watching the goings on as Mr. Copeland is not on the stand, it has been publicized. It has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interests he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know. I guess they're, you know, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. And I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interests of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least. And if it goes any further, find that actions by people other than the state have led to us being where we are, because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch, because now he's been told he's going to be hammered by his attorney. I guess he told him that I guess the state's going to hammer him. I don't even know what, but Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to a mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances. We'd ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial. Mr. Steele, at this point in time, I'll note that you've made it. I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this, but there's a great investigator who is looking at me and I trust her. I'd like to call her to witness. I was told I was not there. I was told that, I forget her name. I know her first name, but her last name. And Investigator Long, and I may be wrong, heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo, if I have to go to jail, then lock me up. And then the Honorable David Botts said, the Honorable David Botts told me as I was walking in that he heard, he's right behind me, so he should be speaking for himself, but he heard Kenneth Copeland tell the prosecution, if I said the wrong people, please correct it, that he's invoking the Fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury, we avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements. Okay.
Well,
so I'm going to
remind it all the time because I live them. I'm just telling the court that in order for you to deny my motion for a mistrial, this is bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time, okay? In terms of this motion for mistrial.
Well, I'd like to call the witnesses, but I understand what you're saying.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine, okay?
May I add a proffer, Your Honor?
Yes.
As you know, we are in a side room off the hallway on the first floor. That's where defense counsel, it's kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach, and I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. It's my belief agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making a...
How do you know it was on the phone? If it was Kenneth Copeland's on the phone, was he talking on the phone or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular
He's saying,
purported conversation.
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was
Okay, but
no interactions with
okay, but here's the thing. I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is.
I believe that the state was on notice that something like this was going to
Okay, all right, but all of you have kind of, like I said, either unwittingly or I just remind you from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this. Do not let outside influences, influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these witnesses will testify to whatever they're going to testify to. So
The defense has done nothing.
I didn't say you did anything wrong. Okay, but I did.
I've heard is that the state.
I didn't say you did anything wrong, but
I understand,
okay.
Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I thought we.
I don't know of any
Okay.
defense counsel that's had any conversations with Kenneth Copeland at all, and I just want to make that clear. Today, I don't know of anyone that's had conversations.
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer, and that lawyer can make that decision, and so can Mr. Copeland. So
Situation because we have
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you. Okay?
Okay.
All right.
Judge, I would like to hear.
Yes, sir. What does he like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal. I
don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you, and I know you have known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Ms. Hilton and Ms. Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland. About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So I talked to the witness because.
When did you talk to Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us. Again, we showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it that I get this idea that you've been talking to my client and then my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But whether or not,
And Your Honor, it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't even that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
no, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay.
Of course.
And that sometimes has to be explained to witnesses and clients. Okay. All right. So that's where we are at this point in time. Is that Monday morning I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So, we'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to, ask that the court, convey to Mr. Melnick to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
All right. Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay?
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
I think Mr. Adams is back. I have a.
He is. He's right behind you.
Sorry. I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to the.
Where is Mr. Copeland out?
No, he's upstairs.
Okay, good. All right.
Yeah, come on down. Don't come in the courtroom. Come when you get your license.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this... I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me who you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt. Because That is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get your information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sum and substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not
sure. I don't want to hold you in contempt, but this is that serious,
Judge.
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well,
do we know if Ms. Bumpus has rejoined us this morning? Okay, all right. Thank you, madam.
Excuse me, Your Honor, may I bring something up before Mr. Copeland comes in?
Go ahead.
I believe I heard him say on an open mic yesterday, gave his testimony that he may take the fifth today. Can you inquire into that prior to the jury coming out?
I didn't hear him say that, but I can.
Thank you, Your Honor. Your Honor, also,
Pieces of business I have to do, at least for the record. Renew our motion for a mistrial.
Denied. Okay,
Thank
what
you.
else?
And also, again, requesting for the purposes of cross-examination, the transcripts from yesterday.
I'm deferring on that one for the time being, okay?
Thank you.
All right.
To come down, and people told me to go down there because
Is there an objection, sir? Just state what it is. Okay, let me see if he's finished his response. Mr. Copeland, are you finished? Or do you need to say something else to complete that last question you were asked?
yeah, I was just gonna say that I was told to go down there and speak with the police.
Okay, all right.
Do you recall in 2015 telling law enforcement officers that you were calling to get advice on whether or not you should go down and speak to the police because your name was coming up in the murder?
Can you say the first part again?
Sure. Do you recall telling Detective Thorpe in his January 11, 2015 interview that you were calling around getting advice to decide whether or not you should come down to the police department because people were putting your name in the murder?
I don't know. I know when he called me, didn't know what to do, so that's why I was told to go down there. Yeah, I'm finished.
Do you recall telling Detective Thorpe in that same January 11, 2015 interview that people told you not to go down there and to wait until the police called you? But you wanted to come down so you could clear your name.
You said, did I tell him that?
Yes.
I guess.
In that January 11, 2015 interview, was Thug in that interview with you?
Huh?
When you went to go speak with Detective Thorpe on January 11, 2015, was Thug in that interview with you?
What you?
Basis. Okay. Mr. Copeland, can you step outside for just a second? Ladies and gentlemen, jury, can I get you to step in your headquarters just for a minute, please? All right, councils, please be seated. Our jury has left us and Mr. Copeland has left us. Mr. Steele, what's your motion, sir? Can you come to the podium, please, sir?
My motion is that there is a 24-4-403 comment on pre-arrest silence under ORR versus state. I believe it's a 2019 case, but I'll get you the site if it's not. If you put in OR and Mallory.
I'm familiar with OR. I'll look it up, sir.
And Mallory's MALLORY. What the state did is they set up series of questions, repeating the question, that Mr. Copeland gets a call from a Detective Thorpe on January 11, 2015, morning hours, telling him, according to Mr. Copeland, that he needs to come down to the police department. Mr. Copeland is reaching out to people allegedly saying whether I come or not. He spoke with people who said go down to the police department. The state then, for some reason, immediately says, well, did Jeffrey Williams come? That's after the state elicits, it's non-answered because the witness said he doesn't know, that Jeffrey Williams' stepfather's house is supposedly shot up that night. When you put that together, it is a clear indication that Jeffrey Williams should have, if he's involved, since his stepfather's house is being shot up, then he's being accused and he should go down to the police and talk to them as well. There's no basis for that. The state knows that Jeffrey Williams wasn't called by the police, wasn't asked to come down and speak. Why in the world would any prosecutor anywhere in this nation at any time ask a witness whether Jeffrey Williams was there? Nobody would say he was there. Nobody asked him to come. All it does is plants improperly in the mind of the jury Jeffrey Williams was not bold like a lion, like Mr. Copeland, and go face the police that night. I'm moving for a minute.
All right, sir. State?
Yes, Your Honor.
Mr. Steele, if you give me the site for, or if you can find it, please. What year was it decided?
Probably 2016, maybe 19.
It's Orr versus State?
It's State versus Orr. It came from the Court of Appeals of Georgia up to the Supreme Court of Georgia. And reversed our previous demarcation where the state cannot comment on pre-arrest silence. 2 is whether it is too prejudicial versus probative. And here there's zero probative value because the true evidence is that Mr. Williams is innocent of any charge, never asked by the police to come down, and didn't have a reason to go down to, quote, clear his name. So now the jurors are left with the unbelievable impression that somehow Jeffrey Williams should have gone to the police department but didn't, and he hid behind Mr. Copeland. It's just outrageous. I mean, to me, that is, I've tried so many cases, this is just wrong. And the state inquires of this witness, knowing, no matter what the witness said, it's just, nobody's going to say. There's going to be a video played where Mr. Copeland's sitting in a room with Detective Thorpe. I mean, what a crazy thing to say. Was Jeffrey Williams with you when you went to the police? Why, what's the probative value of that?
Well, I'm going to find out, I guess, so. Okay, all right. Thank you, Mr. And the citation for is 351 Georgia App 578.
No, look at the state.
That's State v. Orr.
Look at the State versus Orr in the Georgia Supreme Court. So the Georgia case. I think big counselors already have it. So.
Get the date. All right.
Looks like it's going to be 305 Georgia 729. Does that sound right? But you're like the 2019 case. Georgia Supreme Court.
That's right, Judge.
305 Georgia 729. Is that correct? Yeah, I see it. Okay. All right. It is 305 Georgia 729. All right. Okay, first question is what's the relevance of asking Mr. Copeland about Mr. Williams?
Sure. Mr. Copeland is now stating to this jury for the first time a version of facts very different than what he told police on January 10th, 2015. On January 10th, 2015, and the state will be going into this, Mr. Copeland advised police, specifically I want to talk about what happened on Cleveland Avenue. Mr. Copeland repeatedly in 2015 stated that Little D got into the car. The first time he said that Little D first said they killed Nut. As his interviews proceeded over the course of 6 months, he eventually says to police that Little D told him that they, and he was referencing Shannon, Mr. Stillwell, Mr. Kendrick, Mr. McMullen, all killed Nut. He is now saying today, for the first time, to this jury and to us yesterday, that Little D and Shannon got into the car and Little D did not say anything to him. And that now everything he said back in 2015, he just lied to get out of the trouble. So what we are doing is showing that back in 2015, none of these individuals were present none of these individuals were present in the room when he was speaking to law enforcement officers. And therefore now his story is changing when he has to now testify in court in front of these individuals. So this has nothing to do.
So you're not trying to get into pre-arrest silence?
Not at all, Your Honor. And especially on January 10th, 2015, Mr. Copeland speaks for the first time during that interview about Mr. Williams. But at no point is the state trying to get into any pre-arrest silence. It is solely to show that back then, none of these people were in the room with him, and he gave one version. And now when he has to testify in front of all of them, he's now giving a completely different version than he gave back then.
Mr. Steele, I'm going to overrule your motion for mistrial. I'll note it that you've asked it before the positive of the next question, and I'll make it a continuing objection, okay? Sir, did you hear me, Mr. Steele? Okay, all right. Anything else, Mr. Steele? Before I move on to Mr. Sharp?
I mean, you ruled, so
okay.
I appreciate the mistrial being waged. Yeah.
Okay, all right. Mr. Sharp.
On behalf of Mr. Stillwell, I just want to make it clear. I know the Harvey rule is in effect, but I believe just for the record that the comment, because this is a RICO case, and we've instituted the Harvey rule for a reason, but also specifically, this is a RICO case where the constitutional violations of one defendant affect all the rest of us. We are linked together. We sink and swim together in many ways. I am too moving for a mistrial for the same reasons that Mr. Steele enunciated, and I understand the court's ruling, but for the record, I just want to make it clear that I have specifically joined this motion on behalf of Mr. Stillwell.
I'll note that Harvey rule is in effect and all counsel. It will apply for all counsel that you move for mistrial, and that you posited another motion for mistrial before the positive of the next question. Okay.
Yes. Thank you, Your Honor.
Okay. Anybody else? Okay. Thank you. All right. Like I said, I'm going to note it for all defendants present that you move for mistrial. All right. Unless there's anything else.
Would you consider a curative instruction admonishing the state in front of the jury that this has nothing to do with Mr. Williams, they should not have asked that question, and that the jury should take no adverse inference against Mr. Williams whatsoever?
No, sir, because it's a proper question at this point in time, given the state's rationale over your objection. Okay? All right. Anything else? No, go ahead. I'll let you all take 5 minutes and bless you and do that. We'll be in recess.
Now, during the course of this interview, do you remember if they came in and swabbed you for gunshot residue?
I don't think so. I just remember. I remember he was laughing like, "Dang, man, the guy ain't even dead long, and everybody already saying you did it." I'm like, I don't know why. And I thought he let me go. I don't remember if they did. I don't remember anything further than I showed him my face and he let me go. So I don't remember what took place that day. To say facts.
As the interview progressed, do you recall giving more details about the night of the murder to Detective Thorpe?
I don't understand what you asked.
Let me just ask you this. On the night of the murder, do you remember if Deshaun went to the movies on the night of the murder?
So much going on. I can't. So much was going on. I was all over the place. I don't remember. I can't say what I can't answer those questions because if I tried to, I'd be lying. I wouldn't. I can't really say.
Okay, I understand. Do you remember telling Detective Thorpe that Deshaun had went to the movies and at some point you had given her your brother's car to drive?
I probably did.
Now, earlier I asked you about a Camaro following you inside of your apartment complex the night that Nut was killed. You said, do you remember that occurring?
I don't remember.
Do you remember telling Detective Thorpe that you turned into Carver Homes off of Pryor Road?
I don't know.
And you saw a Camaro and it was flying behind you?
Oh, excuse me. I don't remember what I told Detective Thorpe again.
And that when you turned left, the Camaro went straight, and instead of going to the front door, you went around to the gate?
I guess.
Do you remember telling him that, or you don't remember?
If he said I said it, I said it.
Do you remember telling him that?
I don't remember having a conversation with him. I don't remember what I was telling him when he questioned me.
All right. So the gate card was to Deshaun's apartment and you were clicking it and you couldn't go, so you went around front.
I guess.
Do you remember telling him that, or you don't remember telling him that?
I don't remember.
All right. And that you had your brother to call the police. Do you remember telling him that?
I had my brother to call the police?
Do you remember telling Detective Thorpe that?
I wouldn't know why my brother would be calling the police, but I don't remember if I said it to him. But if he said I said, I probably did.
Do you remember or do you not remember?
I don't remember.
Right. And so do you remember telling him that you saw the Camaro fly to the stop sign and it was going so fast that it missed it, but they turned and left behind? And when they turned left, I was in front of them. Do you remember telling him about the red Camaro doing that?
If a red Camaro followed me and I noticed it, I wasn't gonna let it. Okay. I don't remember.
Hey, Ms. Hilton, before we posit more questions, I have a good authority. We need to take a comfort break, okay?
Thank you.
Ladies and gentlemen, given it's so close to the lunchtime hour, how about we just have you come back for 1 o'clock, and then we'll see where the afternoon leads us, okay? All right. All rise. All right, ladies and gentlemen, please be seated. Our jury has left us. Before we go ahead and break for lunch, Mr. Sharp, you can make your motion, and Mr. Matthews, you can make your motion. And I take it that you are making this on the basis of the witness's testimony as to January the 11th of 2015 in regards to the mentioning of your clients. Is that correct?
Yes, Your Honor.
Okay.
Just for the record, it's my objection and my basis for the mistrial is both constitutional Fifth Amendment right to remain silent, which
You're talking about pre-arrest silence?
well, I was going to get to that. There's the constitutional right to remain silent, but also the statutory Georgia
Constitutional
pre-arrest, yeah,
privilege. Okay.
well, also the pre-arrest silence,
All right.
statutory, and Your Honor, we believe that those questions brought attention to my client's my client exercising those rights, and it was an inappropriate question, and we moved for a mistrial based on the comment on my client's silence.
All right. Ms. Hilton, do you wish to respond to that, and then I'll move on to Mr. Matthews?
I could. You go to individually, Your Honor?
Yeah. Yeah.
As relates to Mr. Stillwell, at the time that I'm questioning
Mr. Copeland.
Mr. Copeland, at the time of January 11, 2015, at that time, Mr. Stillwell was not a suspect in this case, so would not be counted on his pre-arrest silence. Additionally, looking at Dinkins v. State. Sorry.
Repeat that last thing. Is it Dinkins, you said, v. State?
Dinkins v. State, which is 295 Georgia App 289, which is a 2008 case. A prosecutor does not impermissibly comment on pre-arrest silence merely by showing that the accused demeanor and conduct during and after the crime, but before an agent of the state questions him and before he knows he's being investigated, were inconsistent with a defense such as coercion or justification.
All right.
Well, the jurors don't know when my client became a suspect or not. So,
right.
I mean, the effect on the jurors, I don't really see how that's relevant.
And cannot further, again, Your Honor, the state's position is we weren't commenting on any of the defendant's sides, but again, to show that Mr. Copeland's demeanor now in court before these individuals versus when he was by himself in a interview room solely with the detective, that his answers are much different. And so that is the state's purpose and reason for talking about who was present with him in the room when he was conducting his initial interviews in 2015.
And Your Honor, just to respond to that argument, what undermines that argument is my client wasn't present yesterday when Mr. Copeland made it clear to the prosecutor.
He was in the courtroom here, right?
But no, he wasn't present yesterday in some side room somewhere where several investigators from the DA's office and multiple prosecutors were all in a room talking to Mr. Copeland while he was a sworn witness in his case. And he let the state know that what I said in prior statements were lies. And
you were disclosed those particular
I was disclosed those
things. I just want to make sure. Okay,
last night.
Okay.
But
before he testified this morning, correct?
Yeah, last night.
Okay. All right.
And so, but the argument that, oh, he's changing his story because he's in front of Mr. Stillwell. Not only is there no evidence that Mr. Stillwell has ever threatened Mr. Copeland or Mr. Copeland is in any way scared of Mr. Stillwell, or any of these other gentlemen, but also the fact that it was disclosed yesterday to the state with none of these gentlemen present undermines their argument that that's the reason for asking that question.
All right. Thank you, sir. All right. I'm still going to deny your motion for mistrial. And I'll note that you asked, as I said before, that you posited before the next question was asked. Okay.
Thank you, Your Honor.
All right. Mr. Matthews, Sr.
Your Honor, as it relates to Mr. Marquavius Huey, our motion for mistrial is based upon the sworn testimony that has already come out from Mr. Copeland on yesterday. Mr. Copeland stated that he had met Mr. Huey in 2021. He had indicated that he had met him in 2015, didn't know him in 2015, or anything of that nature. So it's a bad question that was asked in terms of whether or not Quay was there back in 2015. So that's the first point. He did not know Mr. Huey in 2015. Secondly, Your Honor, that places it's a bad faith question. It places Mr. Huey's character in issue. And there's no basis. There's just no basis for that question to be asked. And because of those reasons, Your Honor, we will respectfully ask this court to grant a mistrial as it relates to Mr. Huey based upon those natures. There's just no good basis for that question to be asked. When the witness had testified on yesterday, not to be repetitive, but he testified yesterday, he didn't know my guy in 2015. So how could he have been there in 2015, or did he show up there at the interview with Detective Thorpe in January of 2015?
All right. Thank you, sir. All right, Ms. Hilton.
Your Honor, the question was a good faith basis. If you can recall, yesterday the state asked Mr. Copeland if he knew a number of these defendants. And so what the state did in order to perfect what occurred is asked about every single defendant that Mr. Copeland said he knew in this courtroom, regardless of time. So that the jurors knew that none of these individuals were present with him at the time. Now, if Mr. Matthews wants to argue at closing argument that was the state shouldn't have asked that because Mr. Huey, he didn't know him, then that's a question for argument, but not a question for a mistrial, Your Honor.
All right. I'm going to overrule your objection, Mr. Matthews, and I'll also note on your behalf, on your client's behalf, Mr. Huey, that you have paused the next question before, made another motion before we paused the next question.
And one more thing just to add to the record, Your Honor. And while I knew that the answer was no, the jury did not. And so we had to pose that question. And there's the one additional thing I want to put on the record after the close of this hearing, Your Honor.
All right. Anything else in regards to mistrial? All right, Ms. Hilton, what else? All right, counsels, enjoy. Sorry.
I would like the court to look into the appropriateness, Mr. Copeland, to my observations around your courtroom, outside your courtroom on breaks, is surrounded by several members of law enforcement with the district attorney's office and prosecutors, potentially other persons. I don't know why a sitting witness under oath is in a room with prosecutors during breaks, mornings, afternoons. It's totally inappropriate. There are people who are in your court's door. There's a double door where the court sits to its right that aligns with the witness chair, and I noticed people standing there in law enforcement while Mr. Copeland is testifying. He's making eye contact with them. I don't know if they're his brother. My point to you is this: what gives anybody the right to surround a witness, he's not in custody, and bring a witness? I'm sure Mr. Copeland didn't say to the prosecutors, I don't know this, Your Honor, so if you think I'm wrong, then just strike it from your memory. But I'm sure he didn't say, hey, you guys want to hang out in this room a little while? So I believe that he is being led on a tether by the prosecutors, and it is coercion. It is inappropriate. And why would anybody not be recording everything he said? And why do I have to get it in drips and drabs? So I am objecting to the tactics of the Fulton County District Attorney's Office and whomever else they may have employed with a citizen, regardless of what the court may think of him or the prosecutors think of him.
I don't have any thoughts. So please don't put that in. Please don't put that in the ether. Okay, but that's what you just said, sir.
The ether is
okay.
Clear. The court wouldn't do it. I wouldn't do it either. So why is it happening?
So I have no interest other than I'm a referee.
Well, you're the referee who spoke with the witness without my presence.
Mr. Steele, we're not gonna get into that right now.
Well,
okay?
my point is, how is he being treated here? And why don't I have all this? And why is this going on? What an unfair trial for Mr. Williams. Think about it. If you were accused, Your Honor, and the judge met with this witness, with the prosecutor, and you sat next to me and Mr. Adams, you would say to us, what kind of case is this? Now he's being surrounded with all this law enforcement. My point is,
Your Honor, we're going to object that this.
I'm not going to be interrupted.
Mr. Steele, hold on. No, but you're Mr. Steele? Mr. Steele?
Yes, sir. What?
Okay.
I want to finish. I'm making a record for the court to understand.
Well, Mr. Steele,
I've never been interrupted in a court except for this one. You allow.
Well, you know, but the challenge is in this point in time is that some of the things that you have said at certain points in time are not appropriate.
It's not true.
Okay, well that's the court's. The
court is wrong.
Well, you know, you have, everybody has an opinion, and it can certainly be reviewed at the appropriate time. But finish up so you can go ahead and make your record.
Interrupt anymore about a prosecutor or anyone. This is a record. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so. Well, we don't know that. We don't know whether or not they're true.
Going on. Every time Mr. Copeland comes in the courtroom or out of court, he's escorted by a DA's office investigator. You see that? This court is observant. You're not just sitting there in a cloud. You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland, and he said, why?
Okay.
Why do I have to bring it up? You should be bringing it up. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial. So I'm moving, again, to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of hold on. You have accused her of misconduct as well. And remember what I told you about your professional response. Remember what I told you about your. And she's going to take me down as opposed to you. So when I start talking, stop talking, please. Okay? I'll let you complete your record. Okay?
I understand the one party talking. I got it.
All right. Okay. All right. So I told you, several times before, I told you and your colleagues, remember your professional responsibility. And let's not make this an ad hominem issue. I don't believe that either one of you are trying to do anything that would subvert your ability to practice law. But
Ms. Love has intentionally lied to the court numerous cases. You do nothing.
Hold on. Let him finish. See, this is Mr. Steele. This is exactly what I'm saying. You cannot. It is not a good idea to state that your brethren across the bar are lying. Okay, in any time or any way.
I don't like doing it.
Okay, but don't. So don't. But don't because you don't because you don't have any proof. If you have proof of it, then if you have proof, there's a mechanism in law and under the rules for you to submit that question to the Office of General Counsel and for the investigation to occur. But please stop, both of you. I told both of you earlier, stop making these ad hominem attacks toward one another. Okay?
Everyone gets attacked. You say nothing.
Well, okay, but I've said something. You're going back to stuff that's happened in the past. So while I'm trying to deal with things that are current. So I told you all most recently, as of about a week or so ago, to stop all this. Remember I told you the world's watching you? They are. So please don't from this point on, do not accuse each other of anything. If you want to go ahead and do it, there's a proper way to do it, but don't bring it up in front of me. Okay?
I'm just making a point that this has been going on and it's abusive. That is my point.
That's your assertion, sir, as a lawyer, okay? And maybe your frustration with everything. Like I told you, this trial's gone a long time. There's a lot of wear and tear, but everybody's got to rise above and be a professional advocate. That's what the system demands of you.
I'm not worn or torn. I am here to tell the court that from a objective, casual observer, could see what's going on here. It's inappropriate.
Okay. At the end of the day, I understand your concern that you have now shared with the court. Okay. All right. State, do you want to respond?
Your Honor, I just ask that the court strike the portions of Mr. Steele's whatever that was to the court regarding personal and ad hominem attacks on members of the state's team. Ms. Hilton will address the merits of the initial argument that Mr. Steele made. But as to personal attacks on members of the state's team, we'd ask that assertions that specific people have lied. That is disrespectful. That is unprofessional. And not one time has any such statement been made by any member of this team about anyone else.
Oh, I think, Ms. Love, in the past, you've made some
I
statements.
have never
about
said
me.
anyone lied.
You made some statements about Mr. Steele and about, well, just let me finish. I'm not done. All right. And about several others of your colleagues. I mean, and it may have been the heat of discussion and everything else. Like I said earlier, there's enough blame to go around for everybody. All right. So, but can we kind of stop that and draw things kind of forward? I've had 2 or 3 conversations with everyone about their obligations as professional advocates under the rules. Okay. And that while the court certainly agrees that ad hominem attacks they don't make anybody look any good. They really don't. I mean, but I'm just saying I acknowledge that. I acknowledge what's been gone on in the past. So, and I ask that you all reflect upon that because, you know, like I said, you can't say some of the stuff that people say to one another can't be taken back. They just can't. So, and that's just something that the court would just have you reflect upon.
Thank you, Judge.
Sides, okay?
And we just ask again that statements like Ms. Love lied be stricken from the record. Those are personal attacks. There's none been made, at least not this day.
I'm not gonna consider your ad hominem attacks. Either one is. Okay?
Thank you.
Or anybody's. All right? Okay. All right. Madam.
Your Honor, regarding Mr. Steele's assertions of our interactions with Mr. Copeland, we have not treated Mr. Copeland any different than we would treat any of our other witnesses in the state of Georgia. He is our witness. If he wants to be around us, he can. If he chooses not to, he doesn't have to be. The fact that he's saying we are coercing Mr. Copeland to speak is clearly not true, given Mr. Copeland's testimony here today. If we were coercing him to speak, he would answer my questions and I would not have to sit here and go in a back and forth and struggle with him. So clearly we are not being influential on Mr. Copeland given our interactions with him outside of the courtroom. So again, Your Honor, there's nothing inappropriate about the state's interactions with Mr. Copeland. He is the state's witness. We can't interact. We have not influenced any of his testimony, Your Honor. And so we ask that, I don't know if it was a motion, be denied that that was what was being asked of the court.
All right. I'll include the state's Exhibit 400, the statements of the most recent email that you have disclosed to the defense in this case, for purposes of the record, and I will also, to the extent that I don't think of. Mr. Steele, let me just make sure. Are you again moving for mistrial, or did you make them within your statement? Did you ask the court for a mistrial?
Yes, based upon the totality of what I said. Yes.
Okay, I'm going to deny that motion, and I will also note for the record that it was that the same was positive for the next question. Okay.